Now, obviously, most of you have heard about probates being mandatory or voluntary. I think most of you must be also knowing that probates are necessary for two reasons. One is in the uh, principal states originally during the time Bombay, Madras, Calcutta, and mainly for immovable property. Now, the question here is, should, of course, up till now, a mandate, probate was necessary. It was mandated for immovable property in these three cities. Outside, you would go to a regular court and get a certificate. The process naturally would be the same. Now, don't ask me why they had a probate in these three cities. I really don't know. Maybe because the process started in the cities and then went uh, to the smaller places. But whatever it is, it was there. And when you applied for a probate, you petitioned the court. That means you went to the court and asked them whether the will on which I'm acting as an executor is good enough for you to certify and that I can then act on the will. Normally, people think of the will as distribution. It is not only distribution, it is also settling debts, which people seem to forget. In fact, the debts come first before distribution. And if you did not take a probate or a certificate and started distributing the assets correctly, I mean, you distribute the assets to the people that the assets go to. Normally, you would say X, Y, Z to ABC, etc., and residue to somebody else. But what about the creditors? Nobody likes to write in his will that I owe so much to so and so, and that must be settled first. No one writes that. Now, suppose you get a probate and distribute the assets. Having distributed them, somebody gets up and says, I am one of the creditors, and the testator owed more to me than the total assets that he has distributed. What do you do? Can somebody tell me what would happen in a case like this? Let's start off with this question. Will somebody tell me what to do if a creditor comes up after you have distributed the assets and the creditor says that the testator owed him more than the value of the assets? What will you do?
Reverse the selling.
I'll repeat the question. Suppose you are the executor, one of the executors. You get a probate. You distribute everything correctly as per the will. No hassle in that. After that, somebody gets up and says that I'm a creditor and the testator owed me X, Y, and Z. Now, X, Y, and Z is more than A, B, and C, which you have distributed. What happens?
Reverse the sale.
They have already spent it. This is something that nobody thinks of. I have yet to see a will which says that I owe this person so much and please give it to him before you distribute the assets.
Hello. Since
Yes,
the probate is there and it is all the wealth has been divided into four people, and somebody comes
yes.
up as a creditor saying that my money is more than whatever you are having the assets. So first of all, we all will deny it and we will say you go to the court and file it. Then we will see what will happen. Then let the court decide. Then we will see. That will be my way of handling this.
Okay. So you are delaying a decision,
Yeah.
just like all lawyers do. You don't want to take a decision, sort of, if somebody asks me a question and I start with, it depends upon. which means that I have got 10 solutions. I mean, 10 ideas, but no solution. So you go to the court. Suppose the court says, yes, the creditor
Yeah.
is entitled to all this. What happens?
Then we will go for the settlement.
But boss, you already spent it. You are the executor. You have distributed the assets. How do the beneficiaries get into the picture? They had nothing to do with it. You have given it to them. You did not
No,
give it to
correct.
them
But
under any conditions. You did not take any.
no, then
Yes, tell me.
yeah, then the court will auction it. Whatever we have taken, whatever the beneficiary has taken, if the court orders, we will auction all the assets. Court will auction all the assets, and they will repay. See, repay will have to be done, though it has been distributed.
You know the Latin saying that nebur debet quod non habet. Nemo, no one. Hab, debet, no one can give. Quod, that which habet he does not have. You are talking of something that happens the day after you get the probate. The creditor has 3 years, maybe more, depending upon what the conditions were. And your assets have been distributed. I'm going into this because I want to show you the problems that can arise with or without a probate. That's why I'm going into this. Because without thinking of all these things, we cannot take decisions. So you are distributed and you distributed very honestly. No problem in that. There's a lot of money involved, cash, um, mutual funds, shares, which you have distributed and the people have used them up, enjoyed themselves, or maybe died and given them to somebody else. What about the creditor? The creditor, what does the creditor do? Hold the hold the executor responsible. Now, here you might say that I had given an advertisement in the papers, which very few people do, or that I had stuck the probate on the notice board. There's a very big notice board in the, at least in our high court, on which these are stuck, and nobody reads them. Some of them just take them and tear them up and throw them away, or they are layered upon layered, which you can't really read. So just don't think of assets as positive, also think of liabilities as negative. Now we come to this. No probate. No probate means the executor distributes the assets. You don't go to court because you say, it's not mandatory, it's voluntary. I've got XYZ, I'm distributing it to ABC, everybody is happy, shake hands, have a nice drink, and go home. Then you have the creditors, not one, maybe 10. Of you are not aware. Please exercise your minds and tell me. Are we talking?
So Shreya is saying that the creditor has to be compensated from the properties of the testator.
But they already spent it. You distributed it and it's already spent. What then? Or maybe the testator had so little. Maybe because he had so little, he had borrowed monies or uh, built up debts.
Sir, it may be divided equally, like equal shares from the beneficiary will be taken and paid to the creditor. Either this might be done, or let's say one beneficiary has got 80% of the property or monies of the person who's making the will, then whoever has got more number of percentage, the creditor may be entitled from that person who has got the maximum number of percentage of property. I'm just applying my mind and making a guess. I have no knowledge about this. Thank you, sir.
You are right that you would want to distribute it according to the shares that each one has got. Or alternately, if two of them have spent everything, then the third one, even if he's got 10% share, would have to settle the dues. My question was not that. My question is, who is responsible? My question is, who is responsible?
Yes, sir. We're waiting to hear that from you, sir.
It's a difficult question to answer. But I would say that the responsibility lies with the executor. If the executor has taken due care to find out what the liabilities are and then distributed, and the creditor has not shown his face in that case, I do not think the creditor stands a chance. You have done your job. The creditor has been sleeping over his rights, and that's the end of the matter. Now we come to the problem on hand, whether a probate is necessary, mandatory, or not. As I said, this is an example that I wanted to discuss with you. At the end of the seminar, we'll decide whether the new law which says it is not mandatory is a smart law, is it a bad law, is it just sweeping the dust under the carpet, or there is no change at all. It's just an eyewash. So one by one, we'll take these points up. The first one is the probate is necessary, compulsory. As I gave you one example, unless you have a probate, it's going to be very difficult to prove by the executor that he did the right job. It will be almost impossible. In fact, the executor might be held for distribution without a probate, knowing fully well that he was doing something wrong. So the executor gets into deep trouble. This is when you say that it is voluntary and not mandatory, so that I didn't go to the court. Secondly, if you say it is not mandatory, it is voluntary. But if one person, one of the beneficiaries, raises an objection, you will have to go to the court. If somebody other than the beneficiaries raises an objection, you will have to go to the court. In fact, that is what is happening right now. Even when you petition the court, that means you go to the court and ask for a probate, and the court asks you to go through certain motions. Invariably, somebody gets up. I don't know how many cases I have had where unnecessarily people get up and raise objections, most of them with an intention of blackmailing. They hold up the asset distribution so that the beneficiaries come to terms. They get tired and say, okay, take this much and that much and let us be. Invariably, it's a matter of blackmail. Now you think of it, a probate, no probate, mandatory, what happens? They'll drive you to court, not only a civil court, but even a criminal matter, saying that you purposely distributed, knowing fully well that I had a share, not necessarily a creditor. I had a share. It happens all the time. And the courts have, well, fortunately or unfortunately, but I think correctly, said been prepared by the testator or read out to the testator. It has got two witnesses at arm's length. It has got proper distribution of the assets. It has got proper executors. Everything is right. But, and this happens all the time. The first thing people say is, this will was under duress or the signature is forged. Right now, I'm defending a will exactly like that. First, they said that it was done under duress when fortunately the witnesses are alive, so they filed an affidavit. The next thing is the signature is forged. Now, the witnesses say that this is something that I have witnessed and this is my signature, yet they say it is forged. And once you bring that up, the court converts the petition into a suit. And that means 2 years, 3 years, 5 years, as much as they want to drag it out. So now tell me, if on the one hand, you have this problem even in mandatory probates, how much of a problem are you going to have in voluntary ones? And then when you say voluntary distribution, why should there not be voluntary distribution even out of the city? Somebody reads out a will and says, okay, this is it. Everybody says, yeah, you are correct, takes everything and goes home. Preparation of a will an execution of a will is 100 times correctly, is 100 times more difficult than normal suits. And this business of either having it voluntary or mandatory is going to create more problems, not less. Anyway, in between that, I would like to tell you a story, which of course is not related to wills, but which I read this morning. Very interesting. I got it on LinkedIn from Umesh Verma. It's a very wonderful story. We'll talk about that when we're having a cup of coffee. But in the meantime, I have opened up a Pandora's box for you. I'm sure every one of you has a question for this. So will you please start one by one, start asking the questions. Maybe don't expect an answer from me. Amongst you, you might be able to come up with some answers. But at the end of the day, I know there'll be more questions than answers. So shall we start with somebody?
So if there are clearly no liabilities, then voluntary probate is the wise path?
How do you know?
No, in case, like, yeah,
In case, but
presuming.
how do you know? You can't say in case. You got to be sure. You don't give an advertisement. You don't let the public know. If there is, in case also fair enough, but how do you know? And how can you take that risk?
Yeah, I understand that, but
If there is no problem, there is no need for courts. The courts exist because there are problems.
but even in the case of an LOA, like I recall a process where
Same thing, sir. Absolutely the same. A letter of administration is that you are appointing an executor. It's the same thing.
yeah, though that was mandatory, sir, but a consent affidavit of a rightful legal heir was missed out.
I didn't get you. Sorry.
In one LOA, the consent affidavit of a rightful legal heir, as the sister of the testator, was missed.
Yes.
The sister of the sort of missed out
Or
in the
whatever it
process.
is.
Yeah, so I really wonder whether mandatory processes, mandatory testamentary processes do offer something sure shot, or whether there could always be something missed out over there.
See, until a court goes through the process, and comes to a decision, it's extremely difficult. It is extremely difficult for anybody to be sure of what will happen. It's extremely difficult.
Yeah, but even after the process was
See, the testator is dead.
yeah.
The testator is dead.
Mm-hmm.
Only he knows what exactly happened. He or she knows what happened. How are you going to find out what was really the case when the person was alive? That's why I think a probate or a certification from the court after due process is absolutely necessary. I believe, anyway, I don't want to give you the answers. You, at the end of the day, all of you get together and find out what exactly the problem is and what the solution is. If one solution or two solutions can be found. You think of all the possible permutations and combinations, not just one, not something that you had in hand yesterday or the day before. Think of all of it that can happen and then decide whether voluntary, mandatory, or otherwise.
Just I want to tell you, you are saying the probate should be mandatory, but I'm
I didn't say
very
that.
sorry. Very
I
sorry to
didn't
say
say
that. No, the probate should not be mandatory. What the government has done, it is a good. It should be voluntary. Yes. So if I am the advocate for anyone, and if without a probate, somebody dies, what I will do is first I will go to the newspaper. I will publish a two newspaper, and is saying that this person has dead. If any creditor has come, please within a 3 months, please contact us. Otherwise, we will distribute the assets, whatever thing. First, secondly, for the probate, don't think you will be angry on me, but I want to tell you on this stage that you are saying the probate. See, don't depend on the court for everything. The court has become the very corrupt judges are there. You will not agree, but I am on the ground. I know. So therefore, and the middle class has benefited from this because 75,000 rupees has to be paid for the assets for the probate to get. So I think this is a very good thing. Voluntary is good, and there will be the cases, one or two, which is something complicated one, the assets. But for the middle class people, it is a very good. Only thing is that without probate, you please advertise into the two newspaper that he is a date. If any creditor has a, please inform us within 3 months, and then we will see. So I think the voluntary is the best mandatory. The court should not be interfering in the assets unless there is a dispute, because the courts, the judges are so corrupt. You will not agree, but I am going through that. Okay, so that's all from my end.
Now, I'll be digressing a bit. No judge can be corrupt if all the advocates are not. Simple as that. No judge can be corrupt if the advocates are honest. Let's face it. How can you corrupt a judge if you are honest? Fortunately, I have not had much of a problem. I did have one very severe problem, and maybe at the end of this seminar I'll go through it. So wonderful that everybody was surprised that such an order can come out of that court. So another thing is, this is an adversarial system. I'm digressing, but since it came up, one person wins, one person loses. If both are happy, then they would not have come to court. It would have been mediated or settled amongst themselves. But a court gives a decision. Sometimes they give it on equity, trying to make both sides happy, especially the Supreme Court. But it's an adversarial system. People go to court, and here again, it's advocates who are responsible. People come to us and tell us, I want to harass the life out of that fellow. बस तुमको पैसा मांगता है इतना मैं दूंगा. बस we tell them that, look, we are here to fight cases. We are not here to fight people. I don't know how many advocates would let go of business like that. A lot of advocates encourage people to go to court. And when they lose, it's a bad case. You can't win. They lose. अरे वो जज बहुत बड़ा चोर है, सामने वाले के पास पैसा खाया. It's so easy to get out of a losing decision just by saying this. And then everybody picks it up and says, yeah. Everybody. I'm not saying they're not corrupt. I have met a couple of them. How can you prove it, or how can you paint everybody black with the same brush? And if you think that the courts are corrupt, don't go there. Go to Don's. Go to Bhai and ask him to settle your matter. So on this particular point, I don't think the answer can be that because the judges are corrupt, it should be voluntary. The executors could be equally corrupt.
And Mr. Malcolm, what are your views on the participant Rajesh sir sharing that, in the newspaper it can be published that within 3 months we'll be distributing the assets?
I'm sorry, I missed out on that. I'm sorry. It is necessary. But when he said two newspapers, I had also already thought of it. I think I mentioned it, that you announced it. But does it mean that all the beneficiaries, if say the testator is in Bombay, all the beneficiaries are in Bombay? Somebody might be somewhere else in the world. That is why the newspaper is not enough. The court will say that you find out who the possible beneficiaries are, that means next of kin, and please bring them to court or get affidavits from them that they are not interested. Why do you think the courts do that? Because the news might not reach those people. Do you read the newspapers every day? Do you read who has died yesterday? There are thousands of people who are dying every day. Are you going to keep a track of everybody who dies, and whether you might know them casually, whether they've left anything for you? Is it practical? So that is why the courts say that inform every possible relative, especially when somebody comes and says, my mother left everything to me. Actually, you have somehow managed your mother's signature. I have known of people who have taken a thumbprint of a dead person The person has been sent to the crematorium with a blue thumb. So these sort of things happen all the time. Now, suppose you get somebody to, when I say you, I don't mean you personally. Suppose you get somebody dead to put his thumbprint or his thumbprint on a hastily prepared will and start distributing the assets. Any solution to these problems? Actually, this matter is going to raise anyway. As I said, you know my views, but at the end of the day, try and make me change my mind. Hold on, what else? Somebody else?
Yes, Mr. Malcolm, this practice is very prevalent where, probate was not compulsory in villages or smaller cities, taking the thumb impression of the dead.
See, if you can get away with it is one thing, but we are not talking of getting away with it. We are
Hmm.
talking of a possible legal solution which sticks. So now tell me, what do we do? Mandatory or voluntary?
All right, sir. So, I had a doubt. Actually, I'm currently working on a case which is related to the execution of a will, and I'm a law student, a final year law student, and my major internships are here in Bombay only. So far, whatever cases I have seen, were the wills where we needed a probate, but now this was one of its kind. But because very recently this amendment came, and now we are not able to decide whether we should really go for a probate or not, because the will says it only mentions about one asset, which is a flat in Mumbai, and no other debts or no other details of any cash or anything, or even a movable property like investments or shares or any other jewelries and all. There's only one asset, that is a flat. And the other problem which we find is a problem with the will is that the testator's identity is nowhere to be given. I mean, there's no identity proof, neither an Aadhaar card, a passport, or a PAN card also of the testator. And the executrix is the sole beneficiary and the sole legal heir of the testator, as she claims. So now it is definitely, I mean, I thought that it was a genius idea because now she's the only beneficiary and only heir. So we do not really need to go for a probate because she's the only beneficiary after all. Nobody else would claim it because it may go undisputed. But now the will itself is a little shady. I mean, we do not believe on the will itself. So what should we do? Should we simply ask her to get it executed without probate, or should we go for a probate because we think that it may not be uh, as authentic as it seems?
Miss Pandey, since you brought it up earlier, I forgot to mention it. The other gentleman, Mr. Rajesh, I think, at that moment I forgot because he mentioned 75,000 rupees. Is
Yeah.
any flat in Bombay worth less than a crore? Any flat.
Yes, right. It is.
What is 75,000 rupees?
Yeah, no,
Is
we do not really
just
mind paying
one minute.
75,000.
I've heard you, now you hear, listen to me.
Sorry.
75,000 rupees initially. A lady executrix did not have to pay a single paisa. It happened sometime about 10 years ago that they changed the law. In fact, we had a case where there was a lady executrix, but since she could not execute the will, another person, a male, had to execute it. And for that, we had to pay 75,000 rupees. And the joke was, when I told the associate, I said it should have been a woman, but he says, at least let us in the court also. We have to run a court, so let the money come in, which I think is okay. 75,000 rupees, no flat is worth less than a crore. 75,000 rupees in that is chicken feed. And you won't believe this. In fact, those of you who are going to be lawyers might love what I'm saying. I have seen advocates charging a minimum of 5 lakhs of rupees. Forget the 75,000. The court fees are tuppence compared to what you will be spending for the probate. I know it's expensive, but if the asset is very small, maybe say 20, 50,000 rupees, a lakh of rupees, 2 lakhs of rupees, we tell the client, please don't worry about it, just distribute it and forget it. You have to take a very practical view of that. But when you talk of a flat, I am right now in the middle of something where only one flat is involved, only one flat. And we are going to, initially, some advocate had said that a probate is not necessary. And well, they did not go in for a probate, and then it became necessary, etc., etc. Only one flat, 75,000 rupees we have paid. And there is no solution because somebody says this is right, this is wrong, this, that, and the other. There are arguments, and the petition becomes a suit. So if you have, and again, the mandatory provision was for landed property, immovable property. It was not for movable properties. Even if you had 100 crores in cash, the probate was not mandatory. The probate was mandatory for immovable property. I was thinking about this yesterday when I was thinking about this seminar, and I asked myself, why was that? And that answer can be found in the Transfer of Property Act. Everything else you can put in your pocket and take away. Immovable property, you cannot. You have to depend on documents. What you actually own is a document rather than the property itself. So maybe because of that, a probate had become necessary for immovable property, not compulsory, but definitely for immovable property and not for other assets. If you read the law, you'll find that it is meant for immovable property. The laws are made after deep thought. Today, you might curse Macaulay for whatever it is worth or his successors. But these laws have come into place after a lot of thought, a lot of experience. We can't just take them and throw them out the window. We are creating more problems by doing that. We are not solving a problem by tearing up a piece of paper. Once you tear up the piece of paper, there is no law. Then what happens? And that's exactly what we are doing. So anyway, as far as your thing is concerned, 75,000 rupees for one flat, I think. No flat in Bombay will cost you less than a couple of crores. Nothing. So it's better to pay that 75,000 rupees, get hold of a advocate who charges you a reasonable amount, file a petition, and if there is no problem, get it over and done with. Then it would take no more than 6-8 months. If there are no problems and if it is done properly. 6 or 8 months is more than enough. Have I answered your question?
Yes, sir, you answered the question. So I think we should go for a probate.
I wish you luck. And if we meet again sometime, let me know what happened. It would be interesting. It's
Sure,
always
sir, sure.
run into people and then they say that, yeah, have you heard you? We discussed the matter. This is how it sorted out. It's always interesting to hear that.
All right, sir, sure.
So with due
Thank you.
respect to your experience and knowledge, I still consider that probate should have been left at the mandatory level. Because in spite of the probate being there, there are many loopholes which need to be fixed. In fact, the court should have fixed the loopholes than doing away with the probate.
So, Fatima, I'm sure
Yes,
that
sir.
you've gone through a lot of these problems in 60 years.
Yes, sir.
At the end of the day, I know that your answer will be it should be compulsory. Let's see what others have to say at the end of the day. They might
Yes,
have
sir.
different views. And from what I have noticed, people without experience, see, it's very fashionable these days to say, this law is bad, throw it out. Too many laws, throw them out. But please understand that these laws have come into place with 3,000, 4,000 years of experience.
Right.
Cicero was alive 3,000 years back before Christ, and we are still listening to him. You just want to throw it out overnight.
No, sir. What I personally feel is, sorry to interrupt you, that probate should be in place. It has been played with a little by the court and the politicians and the legislature to help the rich class who are stuck up because of probate will and in estate which is worth crores of rupees, running into crores, which is beyond the reach of a common man. But if you look at a common man and the middle class who earn hard, who take loans to buy a shelter, of probate is necessary. Though we have other options like letter of administration, succession certificate, legal age certificate, probate should be left untouched. The loophole should be fixed.
You must be listening to my views as we go along. But that
Yes,
is
sir.
one view that it should not. See, a law is only as good as the people who execute it. No matter what you do, no matter how wonderful a constitution is, if the people who are depending on the constitution or taking advantage of it are not fit, no constitution in the world will be correct. No constitution in the law will be correct. And as you rightly said, so many people do so many wrong things. The only thing that I can say is, okay, you have a law. Some people depend on the law, but if there were no law, everybody would depend on a bhai, or they might take the law into their own hands. That's a possibility too. Anyway, you had one other problem, one other matter also which you mentioned. I forget what was it. You said that, yeah. I presume you are a Muslim, Fatima.
Yeah, I'm a Daudi Bohra, sir.
હવે તેની અંદર તો તમારા જાતના કાયદા કાનૂન હશે. And
Yeah,
normally I know you people don't like to go to court.
No, not really, sir.
આગળના વખતના તો નહીં.
Religion is too private.
નહીં તેમ નહીં પણ તે normally matters are settled out of court. Maybe that was the thing, but who knows nowadays.
No, such a big matter is already going on, sir. The fight for power between the two Sayyadnas is already gone to Supreme Court.
When the stakes are high,
yeah.
When the stakes are high, nobody wants to give in. Yeah,
very
anyway.
true, sir. Thank you, sir. Thank you so much.
There is an A merchant.
Yes.
I'd like to hear from that person about exactly what we had discussed just now. Let's see what that person has to say. Or maybe he's just left it on and gone for a cup of coffee. Chalo. Now, who else?
Shankar Rajadak sir has made a point in the chat box. Can
I
we
don't want to speak to that professor because he's going to ask me all sorts of awkward questions, and he was supposed to have taught me properly. He wants to find out whether I have learned or not. So, Professor, I'm not going to answer. In fact, I sent him the invitation this morning. Yes, Professor.
Oh, nice.
Wonderful Professor. He was the only one in class besides my wife and I at 7 o'clock in the morning. Yes, Professor.
Yes.
Yes.
Can you hear me, Bapoo?
Of course,
Yes,
I can
sir,
hear
now
you.
we can hear you.
I've been listening to you for the last 20 years.
Yes. Instead of going to the court, why not? Counseling has been could be done so that the family arrangement can be done, so that the courts will be reduced by the overburden, which are overburdened today. Their burden will get reduced, and something like a counseling can be done for the family members, especially. Then the probate may not be required at all. Even if the person has made the will, and if the family members come together and agree for that settlement, whatever the testator has said, I don't think that the people should go for probate in that case. Your views on that?
Professor, my views on testator's succession are very simple.
Yes.
I would be most pleased if people kept something for their old age and distributed it before they died. That would be the ideal solution. I have 100 rupees. I know that I'm going to require 10 rupees in my old age. I keep 10 rupees and distribute the 90. No will, no nothing. That would be the ideal solution. But how?
But suppose it could not be done, and a person has written a will, and then instead of going to the court, if they come out with some family arrangement, and that arrangement is registered, what's wrong with that?
But, Professor, when did you join us? Did you join us right from the beginning or now?
No, not right from the beginning. Afterwards.
That's why, because this problem we have already discussed.
Okay.
That you do distribute it, but suppose somebody comes up and says, some creditor comes up and says, or some relative comes up and says that I had a share And you know about it. Everybody gets up and says that the will is wrong. It
Yeah,
was
yeah.
forged. Hey, it's a standard excuse everywhere. Two things:
Yes.
either signature is forged or it was done
Yes.
under coercion. That puts it into a
Yes.
suit. Finish.
Yes.
And then blackmail.
Correct.
So I mean, if it when you say that amongst the family set, there a lot of people do that. A lot of people
Yeah.
do it. Not that they go to court every time, especially in the smaller places, villages. They just distribute. In fact, where I'm sitting right now, I know that distribution is done all the time. Nobody goes to court. They might not even know what a probate is or a succession certificate is. But we are assuming that there'll be no problem. If there is a problem and you have distributed, what do you do?
Okay.
You distribute everything according to, I mean, your executor distributes everything according to your will. Everybody's happy. Who knows, in your young age, you might have had a girlfriend. She gets up and says, "Where is my share?" Back to court, but you already distributed. Now, where do you get that money from? It's a very, this, this topic is very dicey, extremely dicey. Writing a will in itself is dicey. People ask you, why do you want this much of money for writing a will on a piece of paper? The number of questions you have to ask and the number of permutations and combinations, you can never get something called a perfect will. You can never get it. Something or the other is left. And then, of course, the testators are not totally honest. Nobody wants to tell you.
Yeah.
Nobody
Yeah.
wants. The truth.
Thank you.
Truth and nothing
Thank
but
you.
the truth, but not the whole truth.
Yeah. Thank you. Thank you, Bapoo. Thank you, Bapoo.
God bless you. God bless you. And
Thank you,
thank you
sir.
for, and Professor, thank you for teaching us. We'll never forget that. Contract 2.
First of all, I am agreeing with that family settlement agreement that should be registered, and there is no need of the probate. You are saying the probate is one of the it should be the mandatory, or one or two people have said, and along with you, because why it is only mandatory for the Hindu, Jain, Sikhs? Why not all religion? It is from the starting point, from the Britishers' time. Why it is left for them? Why it is hurdle for only us? It should be to all, if it is a mandatory, because the Muslims also have assets. They will also have assets. They have been excluded. Why? So this type of the discrimination should not be there. So it is, I think it is a rightly, it should not be mandatory. And what I say is a family settlement is a one of the options. It is very good. People should go for the family settlement. I think the probate, it should be abolished, not only mandatory, necessary, it should be abolished. Let people solve their own problem. Why everything the court has to come? I think you are the renowned advocate. That is why you have not gone to the stress of the middle class people, how the judges and how it is very, at your time it may be the court may be good, but now you come and go to the court and see what is the happening. So I am in the opinion the settlement of arrangement of family is very good. There should be no probate, though you are not agreed, but I think this is a correct one. That's all.
Are you an advocate?
Yeah.
Mr. Rajesh, are you an advocate?
Actually, I have done my LLB in 2007, and I
Yes.
am going to retire after 3 months, and then I am going to start my advocacy. But
When
since for the
you go to
secretary, I
your
am of the middle.
you go to, I thought so. I could imagine your angst and your anger. You are unfortunately, please excuse my saying so, half knowledge. Maybe 5 years, 10 years from now, if I'm alive, we'll
See,
have a discussion.
I am 50
We'll have
because
a
I am a
discussion.
secretary of my society, and I
That's
knew
right.
this problem.
I understand that because secretaries of societies, I had a feeling secretaries of societies are distributing assets left, right, and center when they have no right. Let me be very clear on that. Don't try to teach us the law. The secretary does not have a right. It's a landed property, immovable property cannot be given without a probate. So don't talk to me about distribution. And if you
This
have been giving it, you are going against the law, sir.
the family settlement arrangement has been.
No family settlement as far as it's mandatory in Bombay. Maybe out of Bombay, yes. But in Bombay, it is mandatory and you are breaking the law, sir.
See,
I'm sorry to
MCS
tell
Act,
you. I am
Can you
sorry
see
to tell you that it
MCS
is mandatory right now. It is mandatory. And if you have been doing it, you have been breaking the law. I am aware of this. I know hundreds of secretaries who are transferring properties left, right, and center.
But I think, Mr. Malcolm, most don't even make a will, right? Then they have to.
See, that's another problem. Just because
Yes, most don't make a will.
now on the problem of society. Mr. Rajesh, what do you do with people who are nominated? Do you transfer the property to them? Mr. Rajesh, I want you to answer the secretary of the society. Somebody leaves, somebody dies, and he has left one or two, or maybe say that's a nominee. What do you do with that? Do you pass it on to the nominee? Make the
No.
nominee the heir?
No, nominee is just he will be the member and he will pay all the maintenance. When he gets the higher certificate, if interested his father is died or there is a no will, I will say go to the higher certificate, get the higher certificate, then I will transfer to your name according to the higher certificate.
But I thought you did not want to go to court. You
Ha,
said courts are going to take a lot of time.
So there is a one person for the last 5 years he is fighting interested. There was a no will and he was fighting for the 5 years, but still the court is not giving any higher certificate to him. Though the sister has given the relinquish certificate saying that I don't want the property, and the court the judge is not means listening to him. He is saying I will transfer this property to you and your sister. When the sister is ready to give the relinquishment, why you want to forcefully do that? So for the
Okay,
4 years.
Just 1 minute. I'm sorry to interrupt you. Has
Yeah,
the
yeah.
sister gone to court personally?
Yes, yes,
And she has filed an affidavit to that effect?
yes.
And still the judge does not listen to
No, he is
the
saying
advocate?
no.
Why don't you appeal? Why don't you go to a higher court? Because if the judge, if now I'm not assuming anything else. There might be some other problems. The judges are not fools. They are very smart people. They see these things each and every day. And he might feel that between the brother and the sister, there is some sort of jangling going on, and somebody else is also an heir. They know from the demeanor of the persons, from the way the advocates present the case. Even if the advocate is a little bit doubtful in his delivery, the judge will know. That is why these things happen. The people think that a judge sitting there, if I tell him it's X, Y, and Z, it has to be X, Y, and Z. No, there could be a lot more than meets the eye. I don't know. I don't know the case, but I have a feeling that there is a lot more than meets the eye, and the judge is waiting. See, after all, a judge, when he gives a decision, he is responsible for that decision. He can't give any decision which can be overturned. They get points. If 9 out of 10 of his judgments are lost in appeal, the fellow gets negative marks. He doesn't get a promotion. So they have to be careful as to what they do. Now, I don't know if this is the only thing, then I think the judge is at fault and you should appeal. Otherwise, I don't know. There must be something else to it. We don't know.
I'm telling you, everyone say appeal, appeal. You know how much money, if you go to the high court, how much money he has to pay? How much, at least 2-3 years he has to go for it? How the hurdles will be there? It is
Mr.
not.
Rajesh,
Yeah.
Just 1 minute. Just 1 minute. Mr. Rajesh, as the secretary, you transfer it. Go ahead and transfer it. But if there is a problem, it will lie on your head. If you want to you want to interfere in the process of other people. After all, you are not a relative. Let them sort it out. Why are you interfering?
His father was very good.
It is wrong for you to interfere. Now I understand what the problem is. It is wrong for the secretary to interfere. The secretary just says, go and get me a certificate, go and get me a probate. After that, I will handle it. Why do you want to get involved in this?
Because he don't have the father, and his father was my good friend, and I know
No, sir. Good friend. Everybody is a good friend. Now the good friend is gone. You are not a relative. You have nothing to do with it except you as the secretary. Tell them to get the certificate and then say, I will transfer it.
Yes, sir. So
don't get involved in this. No, sir.
One point I will make here. See, I have, for 2 magistrates, I have already given a complaint to the Chief Justice of the High Court of two magistrates, they have transferred that two magistrate, but they have never taken any penalty on them or nothing.
Have you done it? Have
Yes.
you done it?
Yes, I have done it.
Why? Who are you to do it?
Because on not this case, that was another case of
Now
the
we
society.
come to another case. Now,
Yeah.
Mr. Rajesh, I think we'll knock it off at that.
Okay.
But I'm telling
We'll
you
take
very,
it. Yeah, we'll
I'm
take it to
telling you
some
very
other
simply,
discussion.
Mr. Rajesh,
Yeah.
as the secretary, do not transfer any. After all, people are holding shares in a society. Remember that. Nobody owns the flat. You own a certificate. Nobody owns the flat. Just a minute. You own a certificate. The flat belongs to the society, the cooperative society. Everything belongs to the cooperative society where you own shares. You are only transferring shares. That is one thing. The second thing is nominees everywhere else can claim in a society, as I think you rightly said, a nominee has got no privilege than being allowed to spend money. That's the only privilege that a nominee has. Unless, of course, it can be proved that the nominee was the rightful heir. And the thing is, now tell me, very often a will says Mr. X and the nominee says Mr. Y. Why is that happening? Why is that happening? Why can't you put Mr. X as the nominee as well as the heir? Why is this happening? I want to know. Why aren't the secretaries telling people that, look, this is going to create a problem? Don't give me 10 nominees. Just because somebody comes and says, make me a nominee, you sign a piece of paper and give it and say it's a nominee. This is my nominee. When the nominee has no right except the privilege of spending money. And how many secretaries don't do that or don't do what is necessary? Sir, I'm very sorry, but cooperative societies are the most uncooperative people in the world. And these problems occur each and every day. Keep out of it as the secretary. You have no right to interfere. Please, even if it's a good friend of yours, maybe you can advise them, but please keep out of it. You don't go to court. It's not your business. Let them sort it out. The secretary is only meant to run the society, not run to court and get decisions. So anyway, I'm sorry. I got emotional on that, but these sort of things really upset me. Anyway, now next.
Sham sir.
Yes, good afternoon.
Good afternoon.
Thank you for the opportunity to listen to you once again. I'm not an advocate. I'm a corporate consultant on business management.
Very good.
And thank you for the opportunity. I'm listening to you maybe third, fourth time, and I always enjoy it. The kind of experience which you have.
And more controversial than others.
No. And that too, enjoying from the farmhouse of yours. Anyway, two questions. One is the clarification, not a question. I heard some time ago from you only when you were talking to a lady. Probate is not compulsory but must for immovable property.
Yes.
This statement I found little contradictory. Can you just clarify mandatory, compulsory, and must? So this is one part of question. And the second part of question, can I ask now or afterwards? After you finish this.
One by one.
Okay. So if you can clarify this. Probate not compulsory but must for immovable property. This statement. I was a little confused.
Yesterday with Mr. Verma, we were discussing this on LinkedIn.
And I joined a little late, huh? So
that's okay.
That is a caveat.
We were discussing the word shall. And I have always felt that shall is a mixture of should and will. But it is not must. Just yesterday we were discussing this matter. It is not must. A mandatory means must. It has to be. There cannot be a play on words. A shall can be anything. Yes, no, maybe. But if it's mandatory, it must be must. So when we say mandatory, it has to be must. It has to be done full stop. That's otherwise, what is the sense of using the word mandatory? It's a mandate. You do it. That's what it says. A mandate is given to a person to do something.
No. My question is not that. My question is the statement fit into my mind when I heard you. Probate not compulsory but must for immovable property. This statement only I am concerned with.
Yes. As I said, I did not. I mean, since the last day or two, I have been trying to figure out why it was done. and I think I mentioned it earlier also today. I have a feeling that it was done because an immovable property is not something you can put in your pocket and take away. All you get is documents, papers. Only those you can take away. Now, if I have maybe this pair of spectacles, somebody gives it to me, wills it to me, I wear them and go away. But immovable property you can't take with you. Maybe because of that, they insisted that there be a probate and documents will be shared so that the rightful owner, can show that piece of paper anywhere in the world, saying that I own this property. The court actually gives you a piece of paper saying that you are the owner. This is how I think of it. It may be different. But having thought about it, I think that must be the only reason why they insisted on a probate for immovable property. Maybe because immovable properties are invariably more expensive, more valuable than a pen or a telephone or something like that. Maybe because of that. But I have a feeling that because it is, see, if you look at transfer of property, you may not have studied it. The Transfer of Property Act deals with immovable property. It's a very big act. But does it mean that everything else is not property? It should, if it is dealing with landed, I call it landed property because people understand it. If it is dealing with landed property, it should have been transfer of immovable property and a separate transfer of property. Now, it's an anomaly. Maybe it's over the years. But I have a feeling that because it cannot be taken away and only documents can be exchanged, the court insists on that. This is what I feel. I'm not very sure. If somebody else comes up with something else, I would be very happy to hear it. Gaurav, what is your next question, sir?
The next question is, a father wants to transfer a property on his son's name, but
Yes.
that particular society, when the flat was being constructed, I mean, the buildings were getting constructed, there were some accounting issues and with malafide intentions or whatever. So as a result, some flats, the payments, although paid, they were shown as not paid, but the amount is small in terms of thousands. But although this is the case, the office bearers then have given a statement that there is a nil balance, but unsigned. And this was because of, as I said, the malafide intentions. The document is there, duly printed from the society office, that this is nil balance. So, and as a result, the flat is not getting transferred on the son's name. What is the course of action? What is the stand?
Sir, there are too many ifs and buts. People normally, and this also, I had a case just a couple of months back. People try to take shortcuts. Shortcuts do not work in law. You have to go back. They do not work in law. No shortcut works in law. What you have to do is get hold of a good lawyer and correct things from day one. Until you correct things from day one, please don't do yesterday. One by one, whatever the problems are, have them corrected. Normally, what people do is, chalo, the same order, and somebody does something or the other. You said, no due certificate without the signature. What? It's a piece of paper. I can prepare 100 and give them to you. No signature. Nobody's responsible. So please go through every step of the way. And I'm sorry, I'd like to go to something else because we can't discuss personal problems here. Otherwise, there'll be no end to it.
Good afternoon, sir. I'm Nishit here. I have
Yes,
posted a question before. I think it is not clear on the chat. I'll repeat the question again, make it more clear. So there's a case wherein a partition suit is already been filed. There exists a will also. However, since the existence of will makes the partition suit, would say, non-maintainable, should be filed in testamentary towards the testamentary petition. Is it
Nishit,
correct?
Nishit,
Yes,
join
sir.
me in the So join me in the City Civil Court, courtroom number 63 on the 14th of this month.
Okay, sir.
My client has a will in place. It is being challenged as a partition suit.
Okay.
Exactly what you said. And
Okay, sir.
I'll tell you, because its property is worth less than 10 crores, I think next week I will have to go to the High Court and get a stay. Because you can't have two opinions in the same matter, especially concurrently.
Exactly.
Suppose one person says X, suppose another one court says X, the other court says Y. Obviously, the higher court will hold the day. But why go through all that trouble? Unless, of course, you want to extend the matter over years. Are you an advocate?
Yes, sir. But I
Please,
do not practice on.
245 City Civil Court, room number 63.
I will certainly see you there, sir.
Please come there. I have exactly this problem on my hands, and I will have
So
to.
this is in High Court because all the collectively all the property, the valuation of the property is more than 10 crores. I mean, it's been made.
You are
That's a separate
lucky.
story altogether.
You are lucky. This matter has been transferred because it's less than 10.
Okay.
If you are in the same court, I'm in two courts.
Okay.
I think you understand the problem better than the judge does.
I do, sir. So just wanted to understand because of the recent amendment, whether this will, I mean, the probate will still be needed or no?
Exactly what I thought also. That will it be needed or not? But I think that since we have paid the amount and we have asked, we will go through the process. I don't want to leave anything hanging.
Okay. Okay, sir.
I really don't want to leave anything hanging. But I'll be most happy if you come there and guide me as to what to do.
I'll seek your guidance, sir. But I'll definitely see you there, sir.
No, two heads are better than one. Maybe but do come. Please do come. I wish I could see your face and I'd be able to recognize you.
I'll just try to.
Sushan, please enable Nishit sir's video.
Yes, I have
Nishit, okay.
Yeah.
I'll see you there.
Sure, sir.
I'll see you.
Thank you, sir.
Exactly what I have on hand.
Okay, sir. Thank you.
I said I read something very nice this morning, so we'll take a bit of a break from all these heated arguments and talk about it. It's not related to wills or anything, but it's something very interesting. All of us know that everybody has to be represented in court by a lawyer if he or she wants it, right? We can ask for representation. Even in a civil matter, you can ask for representation. Very surprisingly, this matter did not come up in America until a few decades back. A person, Earl Gidgeon or somebody like that, believed that he got out of 8th grade, which means semi-literate, spent his whole life living off the streets, no home, no nothing, would get caught for small things, maybe breaking some small law or the other, jaywalking or something, go to jail where he would be fed, get out again, beg and plead. Spent his whole life that way. One day he was found somewhere and somebody said that he has robbed some place and they found a few dollars in his pocket and some food for which he was arrested. He went to court and he said that I'm innocent, but I need a lawyer help. The judge says that I agree with you, but the law does not allow me to give you a lawyer. You have to get your own lawyer, whether it's pro bono or paying, that's a different thing. But I cannot appoint a lawyer except in the matter where there is capital punishment. Now, this is America a few years back, mind you. And the poor fellow goes to jail. And I don't know why, for the few dollars and the food, he's sentenced to a maximum of 5 years. Maybe because he had a track record. He's sentenced for 5 years. In court, he starts to study. And he finds out that the Constitution is in his favor. Two things he finds out in the Constitution. One is that everybody has a right to be represented. And the second thing is fair trial. So he approaches the High Court, I think the High Court of Florida or something like that, because they have High Courts for the states also. The High Court tears up his petition and throws it away. No go. The fellow takes up a piece of paper and a pencil and starts writing to the Supreme Court. Normally, the Supreme Court gets so many petitions every day, but somehow or the other, this petition to the Supreme Court of America is read. The justice decides to go ahead with this man's plea and appoints Abraham Fortas, which one of the greatest lawyers at that time, to defend this poor man. Of course, Abe Fortas was a great lawyer, and he takes this case up. And he solves the problem in only one sentence. He asks the court, I don't know whether you people have heard of the Scopes monkey trial, but in the Scopes monkey trial, there was a problem with teaching evolution as against Christian scriptures. And Barrow was facing criminal charges. Barrow, being the greatest crime lawyer in those days, appointed another advocate to defend him. So Abe Fortas asks the Supreme Court of America that if the greatest lawyer in America, the greatest crime lawyer in America, had to depend upon another lawyer to defend him, why can't this poor man? And on that one sentence, the law was changed, which said that everybody has a right to legal representation by a trained lawyer and to a fair trial. If you know what Miranda, they said that Miranda was arrested about 30, 40 years ago. And in court, he pleaded that I was not informed of my rights. So whenever an American cop arrests somebody, he reads out Miranda to him. It's called Miranda. It's a statement which you have to say that you are under arrest. Whatever you say will be used against you in a court of law. But it also says you have a right to remain silent and to legal representation. So from a poor fellow who was almost a beggar, 220 million people in America today have a right to free trial. I think it was a fantastic story. What do you think? Just one or two people, what do you think of it? The importance of a fair trial, the importance of going to court to get a decision. People will say that you go to court to get orders, judgments, but not justice. Maybe, maybe not. I don't know. It all depends on what the case is and how it is presented to the court. A lot of it depends on the advocate who presents it. But anyway, okay, fair enough. If nobody has anything to say about it, let's go on to our topic again. Who else has a question on whether it should be mandatory or whether it should be voluntary? Or whether it should, when you say voluntary means nothing at all. Somebody takes some piece of paper and distributes the asset and everybody goes home. That's voluntary. No procedure whatsoever. Voluntary does not mean you give an advertisement or you wait for somebody. That the law does not say that voluntarily you must do this, that, and the other. It just says voluntary probate is not necessary. That is half a law. It is not the full law. And it is going to create more problems than it is trying to solve. People will say, 75,000 rupees, bacha lete hai, why go to court? Advocate paisa lega, time lagega, all sorts of things people will say. But I guarantee you there'll be more problems. In fact, there'll be criminal proceedings instead of just civil ones. Just wait and see.
Also, Mr. Malcolm, the Supreme Court.
What is it?
The Supreme Court judgment where a mere registration does not establish ownership of property.
Yes, absolutely right.
Yeah, so that also then is a very risky affair without a probate. Yeah.
See, Malvika, suppose you have some property and you give it to me. Documents are prepared. We go to the registrar's office and pay money. What is the registrar's authority? Where does it start and where does it end? He will read the document, hopefully, all of it, decide that these are the fees, and you pay the fees. Is he a judicial authority to decide whether the transfer is legal or not? For all I know, that property might not be yours. There are some documents prepared. The register is not going to go through the veracity of the documents. He just take the money because it's his job to collect the money and you want to pay it, so he takes it. On paper, it belongs to you, but does it really belong to you? Somebody said that, that gentleman who said that there's a long line of mistakes and faults. We look at only the last document. What happens? Divya, my wife, is into due diligence of properties. 20 years, 30 years, they go back. Some of them have gone back before independence. You got to know what has happened. Just paying the fees is not enough. Right now, where we are, everybody says we have paid the money to the panchayat. That makes the property ours. How can that be? Even if I'm a landlord and somebody comes and gives me money saying that this flat in which Malvika is staying and this is her rent, I'm paying it. He pays it to me for 2 years, 3 years, 10 years. Does the flat become his? And does the no, it's still the tenant is still Malvika. Somebody else pays for it. I take the money. I'm not going to refuse the money when I receive it. So the registrar also takes the money and does it. Now, when problems like these occur, and this is the law, and it's a sensible law, we are talking about transfer without probates. Can you imagine the amount you are getting? Everybody was very happy. Arey, probate ka zaruri nahi hai. 75,000 rupees saved. Advocate ko paisa nahi dene ka. We'll do this, we'll do that. I'm telling you, you're going to have more problems. And right now, I'm telling you what the problems are going to. People will misuse this law left, right, and center. Secretaries of society will say, yes, you don't need probate. I'm transferring it. And unfortunately, there are strings attached to these things. Then somebody else will come and say, no, why did you transfer it? It is mine. I have a right or a partial right. Even if he has a 1% right, he can take you to court. So then we start the whole process all over again. Okay, if it's a flat in a society, it is still there. You can fight over it. But if it's liquid and you have spent it, how do you get it back? And what is the position of the executor at that time? It is he who's got the noose around his neck now. Who will want to be an executor and not go for a probate? At least I would not be an executor. I would insist on a probate, otherwise I'd go to the court and say, I'm sorry, I don't want to execute this will. I don't know what the problems are. That would be the safest bet. Or there are 2 or 3 executors. One says go to court, one says no, mandatory. Somebody says voluntary. Somebody says distribute. Who is going to decide which one is correct and what to do? So you tell me. I think this. I don't believe in this law. Leave it as it is. See, Nani Palkhiwala had said a very nice thing once. I'm afraid most of you may not have heard him, but his speeches are still available with the Forum for Free Enterprise. You can get a CD or what do you call it? A pen drive video. Excuse me. He had said a very same thing. He always used to say same things, not just one. He said that in our country, if there is a problem, the first thing is we make a law. It's a knee-jerk reaction to make a law, as if by making a law, all problems will be solved. Finally, you find that you have not made a law, you have tinkered with an existing law. Just like he used to say that people tinker with the budget. There are no structural changes. So here also, I genuinely feel it is tinkering. How can a court tell me you do yes or no? You can do it, you may not do it. Then why are you sitting there? Say that a probate is not necessary, full stop. We won't look into probates. You settle the matter amongst yourselves, as somebody else suggested. Do you think that things work in real life? Do you think people work that way? Brothers and sisters are fighting, literally fighting physically over things. I have known women to fight over saris, abuse each other, pull hair, all sorts of things over saris or a pair of shoes. I have known people fighting over a pair of shoes. Old shoes, mind you, worn out shoes. So where is the question? You are creating more problems. I am sorry to tell you this, but this is my opinion, and I think events and time will bear me out. Don't be so happy that without probate. Or probate, yes, you can go ahead, but think of the problems. I'm not saying that each and every voluntary execution is going to land up in court or in a fight, but when they do, it's going to be terrible. So now tell me.
But Mr. Malcolm, one more point that I want to make. So see these MHADA houses or SRA houses where the property values is like in the western suburbs, okay? Badlapur and all come under jurisdiction of Thana, right? So it doesn't come in Mumbai jurisdiction. So if the property value is say 20 lakhs, 25 lakhs, so that those cases, I think it's better to go for a voluntary asset distribution, right?
You can go in for a voluntary, no one's stopping you, Malvika. But suppose
Yes,
somebody
yes.
gets up and says, I have a share in it. And people do that.
Hmm.
Either honestly they have a share and somebody else has tried to do them out of it by quietly passing the papers, or more likely, they do it to blackmail.
Hmm.
Suppose somebody leaves something to you and I say, no, I had a share in it. Immediately it becomes a suit. Immediately it becomes a suit because the court has to hear me. No matter how stupid or how crooked my plea is, the court still has to hear me. They might throw me out, but it still has to hear me. And in the meantime, you will get harassed. Most of these things in wills, I have noticed, and I've seen a lot of them, they are there only to blackmail. Harass the legitimate beneficiary so that he or she finally gives in. This is how it works. This is real life. This is practice today. Everybody gets up and says, I have a share. Automatically, the petition is turned into a suit and then you fight it out.
Yes, Mr. Malcolm.
Now, how many people have changed their mind after the seminar? See, what you read in newspapers is mostly written by people who have not studied the law. I meet them after I'm a qualified journalist. I meet people in court who are writing notes of cases who don't really understand the law. They just pick up some point which makes good copy, excellent headline, sort of no probates necessary, mandatory allowed. People start reading that. And it is written by a person who's not really studied law or thought of the consequences. It is just a report and half a report. So to tell you the truth, these sort of reports are misleading and they lead to problems. People start to think that whatever they read in the newspapers is God. In journalism, after journalism, I've come to what you see and nothing of what you hear. These people are not apt to write on, and they are in fact misleading people. So whatever you read, please take it with a pinch of salt and apply your mind to it. Is it right? What are the consequences? Are there other possibilities? If I were in this place, what would happen? If somebody else were in that place, what would he think? And finally, you come to one conclusion, only one law. Do unto others as you would have others do unto you. Universal law, nothing more than that. There's only one law. Forget everything else. You ask yourself the question, do unto others as you would have others do unto you. And all your problems will be answered. Only one. So you will apply that one law to whenever you think that it should be compulsory or it should be mandatory or it should be voluntary. You apply this one sentence and then see how to go ahead. Bolo, what else?
Sir, a few participants are saying that how are the other religions managing? There must be precedents in the other religion that without the process of probate, the inheritance has been smooth and successful. So it was only compulsory for Hindu, Buddhist, Jain, and Sikhs, right? And now to create uniformity,
And Parsi.
we
And Parsi. I agree that there should be uniformity in law. I agree. But what sort of This is a very controversial thing, but I'm going to say it. A universal law cannot be a universal Hindu law. It has to be a universal India law. This is where we get stuck. Do you want to go back to Manusmriti? Do you, as a woman, Malvika, would you like to be kept in the house and not allowed to come forward for a seminar because only men can do it? So to say you want a universal law without thinking what the universal law is going to be is extremely difficult. I'm all for a universal law because there should be one law for everybody in the country. But what sort of a universal law? Is it something that I like? Is it something that Malvika likes? Is it something that Professor likes? Is it something that Rajesh likes? How can we, unless you have a law which is equitable and for everybody, you cannot have a universal law in succession. Okay, you have a law that says everybody's marriage is registered. Fair enough. There's nothing wrong in that. Each and every type of marriage is getting registered. Now you say everybody wants a divorce, must go to the court. There were times when people did not go to court. Now they have to go to court. Fair enough. It's a good thing. You go to court and get a divorce. But even now, and a person who is working with me, an advocate, is giving divorce, telling me openly if both husband and wife want to separate, who is the court to stop it? So things are happening, stupid things are happening all the time. I mean, how far can we go? How much can we monitor? A universal law is good, but it should be universal. It should not be lopsided, not for one person or the other. In the same way, succession acts, they should be universal. I know it's a controversial thing, but it's
so Mr. Malcolm, you say that the other religions also probate should be made mandatory instead of making it voluntary for all. Correct?
to tell you the truth, Malvika,
Hmm.
I would be most happy
Hmm.
if a separate court is set up and
Hmm.
everything is decided by the court, or at least a small portion of the process, like saying, give notice to, right now you're supposed to do it, give notice to all the legal heirs, said immediate or not so immediate. You give them in degrees, maybe third degree, fourth degree people have to be informed that we have got this will. If there is no, see, there are times when there is a will and people don't know about it. What do you do then? You go to the court and get letters of administration, and then suddenly you find a will. Somebody has forgotten about it or whatever it is. So I would be happy if a separate unit is set up only to look into wills, and every time there is a transfer of property, a, a smooth, simple succession, like as I said, informing people to third or fourth degrees. Maybe 4 degrees is too much, maybe 2 degrees is enough. I don't know. That can be decided. Give an advertisement in a couple of papers. Here again, if the relatives are staying far away, what do you do? But anyway, something is better than nothing. And then let the court decide. If it is challenged, go to the regular court and get an order, either by means of a probate or letters of administration or what. Because even now, somebody can challenge it after distribution, voluntary distribution. So might as well go through a little bit of a process which the court says you have to go through. Are you trying to tell me that if it is voluntary, people are going to give advertisements in newspapers? Nobody will, because they'll be worried that something will turn up, somebody will turn up. Are you going to tell me that they will call relatives and read out the will to them? And I was on a very important point of
Hmm.
public opinion molding judgments.
Yes.
Everybody says the courts take a long time, and everybody has an opinion on what to do. Keep more judges, quantity, but what about quality? As it is, they say judges are no good, and then they say bring more judges in. So it's a personal perception, good or bad. If I win a case, judge is good. If I lose a case, the judge is bad. Then there's another thing, and see how it affects people. A new law, how it affects. Actually, they are counterproductive. Don't give adjournments. Give adjournments only for 15 days. People started shouting, we'll give you adjournments for 15 days. Do you know what is happening now? Every 15 days we go to the court, or maybe it's 3 weeks we go to the court and come back because the docket is too big. Would it not have been better to call me once after 2 months or 3 months and finish off the matter? 15 days. Everybody says 15 days. On Monday, we have a case over here. 15 days. The judge was not present, the advocate is not present, something or the other happened. Keep a fixed date and then finish off the matter. Give the person time to. The Supreme Court has come up with that, but that's a different thing. Give them time, say that please come prepared, make your arguments and finish it off. Here we go there, 15 days, again 15 days every time. Instead of going once in 3 months, I go 10 times in 3 months. Because the public has to be kept happy. Adjournment was given only for 15 days. The public is very happy without realizing what is happening. The same thing will happen here. Probate. No probate is necessary. But no probate. Let us just divide everything that we want to. We take the law into our, like technically speaking, it's saying we are taking the law into our own hands. I have a piece of paper which is called the will, and I distribute it. I have taken the law into my own hands. If there is no problem, well and good. But if there is, God bless you. Or rather, God help you. It takes a lot of time, but Malvika, you have to understand there are so many people. It's the most populous country in the world.
Yes.
2 people will have a fight. Only 1 person cannot have a fight. If there are 2 people, there is bound to be a fight, there is bound to be disagreement. If there are 3, there are going to be 4 arguments. And who decides? The courts you have to have some sort of law and some sort of a forum where these matters can. Otherwise, people will start shooting each other. I remember one Chief Justice, I think it was Amadi, who said that if you tell me that there are 3 crore cases in court, I'm happy that people are coming to court, they have faith in us, rather than go to dons and try to settle the matter. And another thing, since we are on the topic, let me talk about it. Vacations. Why should there be vacations? Do you know that there are vacations only in civil courts? That magistrates courts work all the time? You have a seminar on that, whether there should be vacations or not. That make it very interesting. And why there should be vacations or there should not be vacations. It will make a very, very interesting topic. It's very hot and everybody has an opinion on it. Chal, anyway, Malvika,
Sure.
thank you very much. God bless you.
Thank you so much, Mr. Malcolm,
And thank all
for
the
sharing your
participants.
expertise.
I wish there would be more.
Thank you so much.